So we're going to do a quick update on what's going on with Judge Glanville and Brian Steele and Jeffrey Williams Young Thug's RICO trial after all the fireworks that happened yesterday. And seriously, shout out to Thugger Daily because they have been all over this case, but they're always sharing the documents, and it's a 2-page letter that we're going to look at. That's going to be really quick. So you can see at the top right here that it was filed at 8:02 p.m. And what does it say? We have an order of contempt and incarceration for Brian Steele. Now, pay attention to the way this is worded and what's cited throughout. On the afternoon of June 10th, 2024, one of the two representatives for defendant Jeffrey Williams, Mr. Bryant Steele, took to the podium and stated to the court that he had been informed of an ex parte communication which took place in the court's chambers. The only parties present for this ex parte matter were the court's official court reporter, representatives from the state's witness, Mr. Kenneth Copeland, or Woody, and counsel for Mr. Copeland. In addition to the court's serious concern with how this information was improperly disclosed to defense counsel. See, notice that it's not a problem that the ex parte meeting wasn't disclosed. The existence of the meeting wasn't disclosed to the defense counsel. That's somehow not a problem. But okay, let's keep reading. Mr. Steele made several claims regarding the sum and substance of the communication that the court found troubling. The court, having told Mr. Steele multiple times that he needs to tell the court how he came into that information, and the court having explicitly warned Mr. Steele that he faces contempt of court should he not comply, the court finds Mr. Steele has repeatedly refused to follow the court's order. Now, what's missing here? Brian Steele referenced Rule 1.6, confidentiality, attorney-client privilege. He said that this is something he came across in the course of representing his client, and thus who he found this information out from should be protected by attorney-client privilege. Now, if the judge disagrees with this, they could have had a hearing. They could have tried to probe into this and figure this out and see if it was really protected by attorney-client privilege or not. But he didn't do that. Judge Glanville did not do that. And he kind of leaves this paragraph pretty vague with that context. He doesn't go into why Brian Steele was refusing. And it's pretty important. You can't tell me it's not important. So we're going to have Glanville cite a code. Every court has the power to compel obedience to its orders and to control the conduct of persons connected with a judicial proceeding. One who disobeys an order or command of the court may be found in criminal contempt. Before a person may be held in contempt for violating a court order, the order should inform him in definite terms as to the duties thereby imposed upon him, and the command must therefore be express rather than implied. And remember, during the oral arguments, Ashley Merchant was hammering down on Judge Glanville, trying to get him to, stick to it. You're trying to impart the worst parts of both criminal contempt and civil contempt onto Brian Steele. But you're leaving out the benefits of both. So which one are you actually charging him with? So now we're getting this order, and we heard yesterday he decided to go with criminal contempt. What does he keep saying in this formalized written order? And here he's citing in Tema v. Smith that says, the question of whether a contempt has occurred is for the trial court, and its determination will be overturned only if there has been a gross abuse of discretion. Now, everything we're watching today had to deal with the judge's discretion. And you guys in the chat or the comments can decide, do you think what Judge Glanville did yesterday was an abuse of discretion, or do you think it was perfectly within his bounds? This citation goes on to say, once an act has been determined to constitute contempt of court, the action the court takes to deal with the contempt determines whether the contempt is deemed criminal contempt or civil contempt. The distinction between criminal and civil contempt is that criminal contempt imposes unconditional punishment for prior contempt, to preserve the court's authority and to punish disobedience of its orders. Now, what's the problem with this line right here? This bottom line here. First of all, this whole paragraph just seems like, to me, in my opinion, that Judge Glanville is like, haha, this is why I was unsure about criminal and civil, when really it seemed like he didn't really know what he wanted to impose. He was just having a knee-jerk reaction to being confronted by Brian Steele about an ex parte communication that took place between the judge with the prosecution present and a witness that was already sworn in. But in any case, this last sentence here, the distinction between criminal and civil contempt is that criminal contempt imposes unconditional punishment for prior contempt, to preserve the court's authority and to punish disobedience of its orders. But what was the argument that Brian Steele was making? Brian Steele was actually arguing the Georgia Code about ex parte meetings, ex parte communications. You can break Brian Steele's argument down to an actual codification, a rule that says, the judge shouldn't be having this ex parte communication. Rule 2.9. Circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies, and the emergency could be that someone was pleading the fifth, but there's a problem because he's already sworn in, and obviously his testimony is material to the case. What else does it say? So, for emergencies that do not deal with substantive matters or issues on the merits, provided that the judge makes provision promptly to notify all other parties of the substance of the ex parte communication and gives the parties an opportunity to respond. This is a rule. This is a Georgia rule. Judge Glanville missed the ball. He threw the ball out of bounds on this one completely. But here in his order, this written order filed at 8:02 p.m. yesterday, Eastern. So at the end, by the time my live stream was ending, this was being written, and after all of the arguments in court, all the time to think about it, the reason that he's giving here, this citation here, he's using this to bolster his argument that the court has the authority to punish disobedience of its orders, as if its orders should supersede what's codified into rules, Georgia rules. And that's not even getting into, I would say there was a Brady violation. Some of the substance of the ex parte communication may have involved a confession from a key witness to a crime that's being charged of the co-defendants in this RICO trial. And they withheld that information. Clearly, that's not immaterial, but they didn't even let the defense know that this meeting happened, let alone that exculpatory evidence came out during that ex parte meeting. The whole separate issue, because I'm sure that's a violation of some state rule. I don't know the specific, but it's also a violation of federal Brady obligations. And it's also worth noting that the prosecution also could have and should have informed defense counsel of this exculpatory information. But they were busy trying to make sure the witness agreed to this immunity deal to give them the testimony that they want. We also get this paragraph from Moody v. State. Direct summary criminal contempt, which arises in the presence of the court and tends to scandalize it and hinder or obstruct the orderly processes of the administration of justice, the preservation of order and decorum in the court, is exempt from the due process requirements of notice and hearing. Now, there's several problems here. First and foremost, right in this paragraph, very explicitly, there needs to be some type of issue of disorder. And the judge didn't make any type of showing that Brian Steele was causing disorder in the courtroom. The second issue is direct summary criminal contempt. And we know that there was some back and forth, but for the most part, Judge Glanville kept saying criminal contempt yesterday and then tried to apply what would really be relevant for civil contempt, which is why Ashley Merchant was like, hey, you've got to clarify because there's a difference here. But the direct summary part is, without further proceedings. So we're going to just, Judge Glanville, I'm going to hold you, Brian Steele, in contempt. We're not going to have any further arguments on this. We're just going to do this. But there's several problems with that. Namely, that it's Judge Glanville's own conduct that Brian Steele is raising questions about here. And then that same person whose conduct is at question is the one trying to issue summary criminal contempt charges against Brian Steele without a further hearing or any type of procedure about it. Second, we know, again, that Rule 1.6, attorney-client privilege, that confidentiality. Judge Glanville didn't even try to probe to decide whether or not what Brian Steele was trying to say, without giving up a name of who told him, who disclosed information to him. Judge Glanville didn't probe further to see if this was attorney-client privilege, if it was work product. He just didn't inquire at all. In fact, there were several times during yesterday's trial stream where Judge Glanville seemingly cut Brian Steele off and was like, no.
That Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd. To me, that never...
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well,
Now, my concern here is he's cutting him off Which means what? Instead of letting Brian Steele finish speaking, he cuts him off. But why is Brian Steele speaking? On one hand, he's making an argument to the judge, but on the other hand, he's also trying to make a record. He's trying to preserve what he needs to say on the record, on the transcripts. And the judge cuts him off. And that's also problematic because there's case law. So though a court clearly has the authority to hold a party summarily in contempt, when necessary to preserve order, Judge Glanville didn't make a showing that there was disorder in the court being brought by Brian Steele. Even such summary contempt power requires. There's no discretion here. This such contempt power requires that the contemptor, Brian Steele, be afforded the opportunity to speak in his or her own behalf. And I would argue further that Judge Glanville wasn't even certain if he was charging criminal or civil contempt. He had to take a recess to think about it and come back after being, really pounded with case law by Ashley Merchant. The judge wasn't clear on which type of contempt it was, and there were several times during what we watched yesterday where Brian Steele was interrupted while he was trying to speak on his behalf. So to finish out this order, it is hereby ordered that pursuant to the court's authority, the court holds Mr. Steele in direct criminal contempt for failure to comply with the court's order. The court order was to tell me who told you. That was the court's order that Brian Steele failed to comply with, without the court further probing into the existence of attorney-client privilege under Rule 1-6, without the court recognizing that its own conduct was part of the misconduct being discussed by Brian Steele, and despite rules existing that would override what the court wants to be its own authority. It is further ordered that Mr. Steele shall be taken into the custody of the Fulton County Sheriff and incarcerated at the Fulton County Jail. This is the Rice Street Jail. For no more than 20 days for this contempt, with those 20 days consisting of every weekend for the next 10 weekends. Mr. Steele is to report to the Fulton County Jail at 901 Rice Street in Atlanta, Georgia at 7 p.m. on Fridays and will be released at 7 p.m. on Sundays. Mr. Steele's incarceration is to start this Friday, June 14th at 7 p.m. and is not to end until Sunday, August 18th at 7 p.m., subject to further order of the court. And then signed by the Honorable Uriel Glanville, Chief Judge, Superior Court of Fulton County. So if you ask me, we're dealing with a situation where it was the judge who violated the rules, Georgia's rules, let alone, federal Brady violations and whatever else. He held an ex parte meeting in chambers with the prosecution and adversarial party to the defense present, while the defense didn't have a chance to be present, while they weren't informed of the meeting, and while they weren't informed of the substance of that meeting. And then he's calling for contempt because Brian Steele wouldn't disclose who told him about what happened in that meeting, without probing into attorney-client privilege and Rule 1-6, anything that could have been work product, without making the consideration to potentially have another judge hear this issue. And then honestly, we get this 2-page filing this contempt order that just solidifies that this ex parte meeting took place. And not only did it take place, but it took place in that 3-hour time block right before Woody came back out and was supposed to take the stand, but Brian Steele wanted to make the argument. So, because this order of contempt says it happened that morning, Monday morning. And to add an extra layer of stupidity, this is shining an extra spotlight on the Rice Street Jail, the Fulton County Jail, where, you've heard me talk about these people that are sitting unindicted in this jail. This jail is falling apart. Judge Glanville hasn't sped up the court calendar to get people that are held without, a bond hearing for more than 45 days, as required by code for a judge to be notified. He's not speeding up the calendar. The Fulton County District Attorney isn't doing anything to speed that process up. Recently, the ACLU helped Bard Business file a writ of mandamus against the Fulton County DA for not following their statutory obligation to notify a judge within 45 days that someone's still being held in this falling apart jail for more than 45 days without an indictment, without being charged. And the DOJ is investigating this jail because there was an inmate that died from apparently being eaten by bedbugs. And there's just so much going on. There's parts of the building falling off. And this is where they're sending Brian Steele for 10 weekends. This is where they're sending someone that just had 30, 40, almost 50 attorneys show up on the fly to advocate for him in the courthouse when Judge Glanville was trying to charge him with criminal contempt. All of these eyes that are now on this case, I hope there's also just as many eyes on this jail and what people who aren't even charged with crimes yet, sitting unindicted, sometimes for more than 1 year, are sitting in and dealing with. So that's really it, you guys. I don't think Judge Glanville's order of contempt really does much except reiterate that he had this ex parte meeting with a sworn-in witness present. He doesn't even include the substance of the argument Brian Steele was making, trying to invoke Rule 1-6 to protect the identity of the person who revealed the substance of this ex parte communication to him. Judge Glanville just leaves it out of the order completely. We essentially just have it solidified that it is in fact criminal contempt and that he wants Brian Steele sitting in this jail because the order of the courtroom was disrupted, even though he made no showing of how Brian Steele caused disorder in the courtroom. So I don't think it's a very strong order. I'll be following to see any updates. I would love to see this. This is attorneys sparring back and forth. Don't forget. That's my favorite thing to watch. But let me know your thoughts. The trial is supposed to resume today. Woody's supposed to get back on the stand. I will be watching over at Nick Starro Trial Watch while I'm getting some other work done. But let me know your thoughts on this contempt letter from Judge Glanville. You guys all take care till next time, and thank you for putting eyes on this issue. It's huge. It's huge. You guys take care. Bye-bye.